Hi, I'm attorney Amanda Schaefer, and today we are going to talk about the difference between K-1 fiancé visas and marriage visas. So which one is better? Well, it depends. It's going to depend on several factors, including your own personal circumstances. So let's first talk about the qualifications for both. In order to qualify for a K-1 visa, you have to intend to marry your U.S. citizen fiancé within 90 days of entering the U.S. You have to be legally eligible to marry. This means that you've either never been married, or if you have, your marriage has been terminated through divorce or the death of your spouse. And this requirement is true for both the immigrant and the U.S. citizen. And finally, you must have met in person within the last 2 years. So that you look at the date you're filing the petition, go back 2 years in time, you must have met in person within those 2 years. There are some exceptions to the 2-year in-person meeting requirement. For example, I know religion, if there's a religious reason. However, it is a very hard waiver to get approved. So if you can meet in person within the last 2 years before filing, I highly recommend doing so. In order to qualify for a marriage visa, you have to be married, lawfully married, to a U.S. citizen or a permanent resident. So with the K-1 fiancé visa, your fiancé has to be a U.S. citizen. Permanent residents cannot apply for their fiancés to come over. But if you're already married, then you can file for the marriage visa. And this marriage has to be a bona fide or good faith marriage. That means that you intend to spend your life together, that you are not getting married simply to get a green card or evade the immigration laws, and it's not a fraudulent marriage. So which is faster, the K-1 or the marriage visa? Again, question we get asked a lot. Usually the K-1 visa, but it depends. And I should mention that when we're asked this question in the context of which is faster to get me to the United States, which is a different question than which is faster to get me a green card, which I'll get to. So usually the K-1. However, this is a huge asterisk that we're putting on it because processing times change all the time. And not only that, it can heavily depend on which embassy that you are applying to. For example, last year I had 2 clients apply for a K-1 visa around the same time. One applied, I believe it was Singapore. The other applied to the embassy in Montreal. And one couple is now married and in the U.S. and applying for the green card. The other couple is waiting for their visa or the fiancé is waiting for her visa interview in Canada. You don't get to choose your embassy, unfortunately, and the embassy wait times are online usually are not very accurate. But I'll run through a typical timeline that I've seen. Again, big asterisks on these estimates that I'm giving you. So you have to file the K-1 visa petition first. That's filed by the U.S. citizen. That can take 6 to 10 months without a request for evidence. I've had them granted in as little as 4. I've had them take 2 years. So again, it can go either way. Then it takes probably a month to transfer it to the National Visa Center, MVC, / the embassy. And then the embassy is going to contact you. That could be another few weeks and tell you what you need to do to get your interview scheduled. So from the time it gets transferred to the embassy, the time your visa interview is scheduled, that could be anywhere from 3 to 6 months. Marriage visa is going to take a little bit longer, and for good reason. When you come on the fiancé visa, you still have to apply for your green card, but not with the marriage visa. So the marriage petition can take 10 to 12 months. The fastest I've ever gotten a marriage petition approved was 30 days once. The longest, you don't want to know. So yeah, that's all through USCIS, but there's more evidence that goes into filing for the marriage visa. Once that's approved, we're gonna give an estimate of 10 to 12 months. Right now, that seems to be pretty on track as of when I'm making this video. Again, it takes about a month to transfer the MVC. You got to do all the MVC work, which is more than you do with the K1 visa. And once MVC, you upload everything to MVC, which usually takes about 2 months with clients. Then you have to wait for them to say, okay, we have everything. We're transferring it to the embassy, another few weeks. And then they finally schedule you for your interview, which again could be another few weeks. So we could say the MVC's process to the time of your interview, let's call it 4 to 6 months. So you're probably getting here faster with the K1. Probably, it's no guarantee. But there are some more differences to take into consideration. So let's look at the cost difference. Let's break that down. For the K1, you end up spending 2 to 3 times as much almost on filing fees alone. So you have $675 for the fiancé petition, $265 in consulate fees. Then when you get to the U.S., you're going to have to apply for a green card. And that's called adjustment of status. That's $1,440. That gives you a total of $2,380. Now, if you want to work or travel abroad while your green card is pending, then you have to now, since April 1st, 2024, pay additional filing fees of $260 for the work permit and $630 for the travel document, giving us a grand total, if you apply for everything, $3,270. Now, for the marriage petition, it's a little less. You're going to file $675 to start. That's the same for the marriage petition. You're going to have a $325 immigrant visa application fee that you pay the Department of State, as well as a $120 affidavit of support fee. Once you get through the process and you're getting a green card, it's going to be $235 green card processing fee for a grand total of $1,375 in filing fees if you're going the marriage visa route. And just to note, this is for spouses who are located outside of the country. I'm not talking about, there's some similarities filing inside the country, but that's for another video. So what about the effect upon entering the U.S. with the 2 different visas? So when you enter on a K1, you enter as a K1 visa holder. It's a immigrant/non-immigrant visa, which is a confusing thing. But part of the reason is because the only way you're allowed to stay past 90 days on a K1 visa is if you marry the fiancé who filed for you. If you don't, you have to leave the country. Once you get married, you can then file for your green card. And if you choose your work permit and travel document, you can file for a work permit based on your K1 status. However, if you do everything quickly, by the time USCIS would get around to approving your work permit, you would already be filing for your other work permit or have your other work permit. So most people don't even bother. So what that means is that you're not going to be able to lawfully work when you first come over. And you got to figure at least 4 to 6 months at least before you can work. And you're not going to be able to travel abroad either while you're waiting, because you won't have a way to re-enter. The marriage visa, what's nice, even though it might take a little longer, like I said, it's a little bit cheaper, as well as the fact that when you enter the U.S., you're actually entering as a permanent resident. And within a month of entering, usually within a couple of weeks, they mail you your green card. And from day one, you have a stamp in your passport that says that you're a permanent resident. So even while you're waiting for those couple of weeks for your green card, you can lawfully work, you can lawfully travel abroad, and you don't have to do anything further. You're obviously married already. You don't have to apply for a green card. You have your green card. In addition, because the wait is generally longer, and there's a rule that if you are married for less than 2 years at the time of your visa interview, then you get a 2-year green card. Usually when you do the marriage visa, by the time you get to that visa interview, it's been more than 2 years of marriage. And that means you're getting a 10-year green card. So the only thing you ever have to file again, if you want, is for citizenship. Whereas the fiancé visa, you're likely getting a conditional green card. Then you're filing it to remove the conditions on your residency within the 2 years, and then naturalization if you desire. And then finally, there's some important evidentiary differences between the two types of applications. So for the K1, it's a lot simpler of a filing. Besides identity documents and stuff like that, just kind of hit at the nitty gritty here, the nitty gritty differences. You need both you and your spouse, your fiance, need to write a statement of intent to marry, basically literally saying that I, Amanda Schaefer, intend to marry my fiance, blah, 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 within 90 days of my entry into the U.S., and I am free and able to do so. Which leads into the second piece of evidence that you need. You need to show that you are legally free to do so. So if you've never been married, not a problem. But if you have been, you need to have that proof of the termination of your prior marriage, but you will need that in the marriage petition as well. And then you also need to have proof that you've met in person within the 2 years preceding the filing of the petition. For the marriage visa, it's a lot more intense in terms of the type of evidence that you need to file. You really need to show that you have a real relationship, and that can definitely be difficult when you or your spouse lives in the U.S. and the other person lives in another country. So this is when we start putting in joint taxes, joint finances, birth certificates of children, things like that. These are things that we're going to end up putting in with the K1 green card application to show that, because you have to continue to show your eligibility for the visa, or for the green card, but you're going to need this in the beginning for the marriage petition. And, especially because the spouses are separated, they want to make sure it's a real relationship. So you can be forward looking and explaining your evidence if you don't have a lot of joint stuff, but that can sometimes be the downfall for people who go that route. However, if you hire an experienced immigration attorney, as like myself and Aaron, we will be happy to guide you to the right choice and make sure you have all that evidence that you need. So the bottom line is both the K1 and the marriage visa are great options to reunite you and your spouse, or you and your fiance, here in the U.S. They do have very different factors to take into consideration. And again, at the end of the day, which one is right for you is going to come down to your personal situation, your personal needs, which is why it's highly recommended that before making the decision on what you're going to do, you contact an experienced immigration attorney to discuss how this applies to your case. That is all for today. Don't forget to like us and follow us, Facebook, YouTube, LinkedIn, Instagram, wherever you are watching. If you hit that like button so you don't follow us. Hit that like or follow button so you don't miss any more of our videos. And if you found this video to be helpful, or know someone who may, geez, I am having trouble talking today, hit that share or that save button. And if you like what you saw, leave us a comment. If you don't like what you saw, leave us a comment. Anything videos you'd like us to make in the future, we're always open to suggestions. We try to put out things that are helpful. So thank you all for watching, and have a great day.